Good afternoon, everybody. Brian introduced me, but my name is Doug Smith, and I'm at Kirkland and Ellis. And I just want to thank everybody again for attending. I want to thank all the panelists. And I want to thank everybody who's watching the live stream of the conference today. We have a very important panel, I think, and I think we saw that from the last panel, because problem number one is addressing claims that are meritless. And I had wanted to, title this panel something like Addressing Frivolous Claims, but I think the censors of the Federalist Society, or maybe it was Brian, toned it down a little bit. And so the topic of our panel is meritless claims. And we have a really great group of people on this panel, very knowledgeable and a diverse set of opinions, I think, on this topic. And I just want to briefly introduce them and then let them get going and speak to you. The first is David Bernick. David is a partner at Paul Weiss and has represented many of the defendants in MDL proceedings. And as somebody who previously worked with David, I can attest that he's very good at coming up with creative approaches to addressing this problem of figuring out which claims have merit and which don't, and actually getting resolution of that issue in the MDL proceedings. Next, we have Chris Seeger, one of the founders of Seeger Weiss, who's on the plaintiff's side, and is a member of some of those dreaded steering committees in many of the MDLs that we heard about in the first on the first panel.
Yeah, with Tim Practo. Oh, okay. I heard you.
And what makes this even more interesting is I think David and Chris also have been recently on the opposite side in some MDL proceedings, so it should make for an interesting conversation. Next, we have Andy Trask. Andy Trask is senior counsel at McGuireWoods. He's been very active in mass tort and class action issues, and very active with the co-sponsor of this conference, LCJ, in developing policy proposals regarding MDLs and also testifying in front of Congress on civil justice issues. Thank you, Andy. And last but certainly not least, we have the Honorable Eduardo Robreno, who is a judge on the U.S. District Court for the Eastern District of Pennsylvania. And among his many other distinctions, Judge Robreno served as the presiding judge in, I'd have to say, one of the most massive MDL proceedings, the asbestos product liability proceeding, bringing it to a successful conclusion. And then notably, he then went on to author a law review article laying out his experience and the procedures that he employed to successfully resolve that proceeding. And I really commend you to that article. It's published in the Widener Law Journal in volume 23. And it's a really insightful article and a real service to the bar that Judge Robreno shared his insights having developed these procedures and resolved that MDL. So we'll follow the same general format with our panelists providing some brief opening remarks. Somebody has a microphone, and the audience members can jump in with questions anytime you want. But we'll have our brief opening remarks and then a discussion with the panelists. And we'll start with David.
Okay, so maybe picking up a little bit with the remarks that I've made by way of a question, I suppose, at the very end of the remarks. I really think that this is a very mature area of discussion, what to do with these MDLs. And the challenge that I think that we all face as practitioners and as parties and as academics is to build on what is now a massive amount of experience and be very granular in what it is that is proposed by way of solving some of these problems. And then, again, being granular to be able to demonstrate why the proposal is something that's going to be effective in dealing with those problems. And the difficulty I think that we face is, first of all, deciding exactly what those proposals are, and then B, being able to muster support from the history, the empirical history of how these cases are handled, to say that that is an apt and a demonstrably effective proposal, so that there then can be real joinder on the ultimate question of what to do, as opposed to kind of more general discussions about the dynamics of MDLs and kind of the underlying problems that drive MDLs. The goal being to have a real engagement, if it's going to be, particularly if it's going to be before panels of judges or rules committees, to have a real engagement at a very specific level so that the people who are going to be making decisions or recommendations are really informed and brought up to speed so that they are empowered to then decide what it is they want to do. And in order, in service of this, and kind of with the benefit of having Chris next to me, I really think the test is, to what extent you can develop a discussion such that people who have been involved in a lot of these cases don't spend a lot of time disagreeing about big picture things, but spend a lot of time agreeing on what are the potential proposals and what are the pros and cons. And ultimately, I think that that's really where this should come. And my own sense from having had the privilege of being on one of the rules committees for a number of years is that these committees are going to come in. The people who are on these panels or committees are going to come in, and they are not going to understand the world nearly as well as the people who are living it all the time, day to day. And the concern is getting to the point where they can really focus and see the pros and cons. And if we spend a lot of time on the broader debates, I don't think we're going to get there. So in a sense, I'm speaking to Chris here a little bit, who I know from many discussions with him will be extremely well prepared to respond. But I kind of put the issues into broad categories, and then I'll talk a little bit about each, and then I'm sure we're going to come down to them. Some of them may seem to have a less tangible attachment to the specific issue of frivolous claims, but they do bear upon issues that ultimately affect the ability to deal with those claims. Number one, just kind of beginning with the basic point, proportionality needs to come to mass tort and discovery. And I don't think that there's really been any effort that I can see to address proportionality in a meaningful way. The plaintiffs will come in and say, well, I got 5,000 cases. Almost any kind of discovery is proportionate. And there's some merit to that position, but I don't think it really comes into traction with the reality that, literally tens of millions of dollars, 20, 30, 40 million dollars gets spent in the discovery process. It's an exceptional amount of money. Having said that, I'm going to set that to one side. I then get to, and I think that this actually starts to be what I think about as being really critical, is that every one of these cases has a narrative. They develop, we keep on picking off an issue here or an issue there. All these cases are a fabric that's woven in the process of litigation. And unless you understand how that fabric gets woven, it's very difficult to pick out individual issues and have a meaningful discussion about them. That, again, is one of the challenges of how do you bring to bear data on the cases. So to give an example, I'm then going to go into this whole business of what do you do with 3,000 or 4,000 or 5,000 cases, and how do you get a handle on what that means. And so I'll tell a little story, which is, that we can come back to it, but just in a nutshell, where do you get information about the pool? And how can you get information about the pool that is meaningful enough that you can frame a litigation agenda with the court, a pretrial litigation agenda with the court that is still grounded in the pool? Because if you don't understand the pool and you don't have data about the pool, you're not going to be effective in talking to the judge about how the case should be litigated. And then, of course, bellwethers becomes the ultimate solution. So how do you get data about the pool? And then what do you do to be able to frame, if this is a process that's supposed to be focused on pretrial issues, how do you frame those pretrial issues so that they have traction with groups of people in the pool? Because that's the way you'll get traction with the judge in saying these issues need to be resolved, and they need to be resolved up front and as priority number one, because that's what MDLs are about. They're about the resolution of pretrial issues. So it's easy to say things like preemption. or failure to warn. A little bit more difficult to say Daubert. Daubert's a big, big mountain to climb for most judges. But the thing that you're really missing out on, if that's all you're focused on, is the fact that a lot of this litigation turns on A, state law, because the cases will be litigated on the basis of state law. The instructions will be given under state law. The law provides for caps on punitive damages, burdens of proof with respect to punitive damages. These are huge dynamics in the litigation. And then fact-specific, case-specific matters. You can get from 5,000 down to 2,000 cases maybe if you do lone pine in some way. But at the end of the day, if you got 2,000 cases, you still have a mass tort. What are you going to do with those cases? If you lose on preemption, then what's your next shot? Oh, is it Daubert? Well, then it's a general causation. What if the judge says, well, I see all the science, but I think that general causation is a real issue of fact for the jury? What's your next move? And a lot of the remaining bulk of the litigation are going to be claims where there was exposure, where if you win on preemption, of course, they're gone, but where there are real problems with state law that applies and with case-specific causation. The plaintiffs, if they are losing cases, if they know that case-specific causation is really going to be litigated on the basis of real-deal science, then they factor that in terms of how much money they want to invest in individual cases. And you start to resolve the bulk of cases down to those that matter, and that's still where you're going to pay money, significant money, unless you've got a way of saying, oh, wait a minute, there are case-specific issues. How do you build that into the pretrial process so that when you think about those Francis cross-cutting issues, the cross-cutting issues are not just the big picture issues, and they're not just, well, does somebody have exposure? Yeah, there's going to be a lot of claims where there's no exposure, but the sweet spot of the litigation is going to still be there for you, and how do you deal with it? And that's when I come to the question of cross-cutting issues and bellwethers. You can't litigate some of these issues in the abstract. You have to have plaintiffs. Well, what are you going to do if you got 5,000 cases? How much discovery are you going to get for any of those cases if you don't have some individual plaintiffs? So you can call them bellwethers, but they're also just individual cases on which you can focus discovery. And this then tees up the question about how you select the cases. That's a very granular matter. If you've got a case, or if you've got a jurisdiction where you've got a lot of cases that are properly situated there, what's your process for saying, well, which of these cases are we going to pick out? And that's now you're down to an area where the plaintiffs have a very direct interest, the defendants have a very direct, and the judge has got to decide. How do you get the judge to decide on the right kind of selection process? Then, with respect to, I've got two more issues, then I'll be done with my brief introductory remarks. What does it mean to say that there's got to be some verification of the claim? Verification of the claim. And at the end of the day, the plaintiffs are always going to say, we shouldn't have to spend money on these cases until they're teed up for discovery. That's what they're going to say. And it costs a lot of money. Well, how do you join issue on that so that the plaintiffs are not being asked, or you're not saying to the judge, go make them do it, and they come back and say, that's a lot of money. How do you join issue on money and burden so the judge has got something to actually think about? And the question is, okay, what is it that you really want, and what's the least costly way of getting it? Exposure is pretty simple in drug cases. Give me the prescriptions. What are the prescription records? It's not that hard. And then with respect to causation, if we're talking about, well, show that at least some evidence, I don't think that's going to get anywhere. But what does that really mean? Show me a bunch of medical records. What does that really mean? I think it really comes down to a very simple question. Is there some doctor, someplace that's actually told the plaintiff, your product caused this injury, and they're prepared to attest to it? Any doctor who's got the qualifications to do it. It doesn't have to be a full expert report. It doesn't have to be a complete review of the medical records. It's kind of make an appointment. Plaintiff gives the history, is the doctor going to say, I believe this person's injury was caused by that product? It's pretty minimal. It creates a real point of focus. It is some assurance. It does cost some money. It doesn't cost a lot of money. Lone Pine, again, if all it's dealing with is exposure, is going to cut a lot of stuff. I think that that's all great. But ultimately, at the end of the day, those cases are going to get cut out anyhow. Because if you're going to settle, you're going to have some way, the plaintiffs will help you cut out the cases that aren't all that good. That's not where you're going to pay necessarily the big money. Finally, interlocutory review, clearly the correct answer. Problem we have to think about is interlocutory review of what? Again, Daubert's easy, preemption's easy. But if you want to frame state law issues and causation issues, you're going to need a case for that. So maybe you want to have interlocutory review, not of summary judgment or Daubert proceedings. Maybe you want to have an interlocutory review where you actually have a case that's been tried, and whether it's been won or lost, maybe at that point in time, you have interlocutory review and you build in some issues that are not necessarily the easy slam dunks that gets rid of the whole litigation, but are very important to the case. Lastly, settlement, I think is a huge problem. I don't know why, I know why district court judges, trial judges, want to become involved in settlement, but I find it is very difficult for me to think of a case where ultimately settlement discussions don't verge on merits discussions and you get commingling, and I think that that's a very problematic situation.
Great. Chris, we heard a little bit about some of the data. Melanie had raised the 30 to 40% of cases that get zeroed out on settlement. Dan's anecdotal experience in Evandia, where they had hundreds of claims that were dismissed out, just lacking basic information. And I asked you, is there a problem, number one, with meritless claims? And two, if so, is the kind of litigation agenda that Dave lays out the answer?
So this may surprise you to hear this, but yeah, there's a problem. I'm not sure the problem's as big as we've heard from people in this room, and I understand why, people who have presented on this, including David, who, may say it's bigger than it is. I get that because I think there's some gray area where we're just fundamentally going to disagree on what a case is. We're going to think the case is one way, you'll think it's another. And there are many cases in that gray area that your side, David's side, I should say, I don't know who's who in this audience, would call not a case, and I would call it a case. I'm not talking about that. We're talking about cases truly with no merit, and that is a problem. I've led a number of cases. I used to think that, hey, they're not that big of a deal. It's better to have these people in the MDL, sort of in the tent, than outside the tent, starting trouble in state court and doing other things like that. So to have them all in the MDL was a good idea, and we just deal with them at the end. But, maybe selfishly, I ignored the fact that there are transaction costs for the other side by having those cases sit around. So I've become more sensitized to that. And as somebody who leads MDLs, I've tried to get better at it. David and I are in a case. We have tried to work through this issue together. We haven't always agreed. I'm not going to get into the specifics, but we've had a number of discussions about these kinds of the cases we're talking about. I'm in a new MDL in the District of New Jersey involving proton pump inhibitors, and it was really an idea that I had proposed to the court that we include with a plaintiff's fact sheet a pharmacy record along with some proof of injury. Now, I know a lot of people sitting and hearing this would say, well, that's not really, that's relatively minimal, but it's not always provided up front, the actual record. And I do think that the fact that we're doing that will eliminate a number of what many people we would all agree on as meritless claims. And those are the claims that they can't even prove they took the drug. So it's a problem. I mean, do I think it's look, it's the subject of our panel, and it's 25% of today. I get that. But do I think it's one of the biggest issues to be addressed in an MDL? I don't, but I will say this, I am wide open if I'm ever in a case against any of you to have this discussion really early about what should be included with a plaintiff's fact sheet. So the other issues that David has raised, which are all really big issues, I mean, I kind of came here with one idea that we were going to just talk about sort of the meritless claim, but you just unpacked the entire litigation, and I'm more than happy to discuss that. The one thing I would like to point out, and this goes to some comments that Tim, you made and fairly made, and I get it from your perspective, but parties do spend a lot of time negotiating the fact sheet up front. I understand that we don't always agree on it, but at the end of the day, we kind of arrive at something that we think is overbroad and asking for too much up front, and you guys think probably doesn't do enough. But that negotiation, I think, is a healthy part of the process. We usually agree on those. Sometimes we don't, and they go to the court, and the court will rule on it. But so I don't think it's true to say that, the defense doesn't have that much information on claims. Now, there is the issue about whether plaintiffs even complete and serve these fact sheets. And usually there's a procedure in place for dismissing those claims or moving to dismiss them. There's a cure period, but there's usually some procedure in place for that. And I also know that we typically agree up front to deliver with the fact sheet, authorizations for medical records. But look, I also know that the trend lately, and maybe somebody on this panel or in this audience can talk to me about it, maybe the issue is just cost, but I think the trend lately has been that defendants do not take those medical records and go out and order records for the thousands of cases. Now, I guess I get the fact that that may be a very expensive endeavor and one that defendants think they shouldn't have to do up front. But that was the way it used to be done. Defendants used to order those medical records, and that has stopped. So I think what's happening is there's a lot of anxiety right now because I think, 10 years ago when defendants ordered all those medical records, they had a better sense of what they had. Now they don't have as good a sense of what they have. But they do know there's some component of those claims that probably shouldn't be there, and I agree with that. So, I guess this is a real long way of saying, in a very unsatisfying way, I wish the plaintiffs' bar and the defense bar could get together, have more discussions like this and more conferences about it, and have more discussions about maybe we can model out a better way, a better fact sheet that some of us can agree to. And there are going to be a number of plaintiffs' lawyers that are going to hate it. And it is a reality of our world that there are plaintiffs' lawyers that do nothing but advertise for cases. They want to park those cases in the MDL and hope for some firm like mine or some other firm that will come along and try cases will settle those for them. I got to be honest with you, I think that's a problem too. They have a First Amendment right to do it. But I would love to have a real discussion on how you can deal with something like that, short of Lone Pine, because I don't agree with the Lone Pine idea. And it's not a matter of because the plaintiffs' lawyers don't want to put money into cases. Tim, we spend, and the firms that lead litigations put a lot of their own money. In Vioxx, there was over $40 million in just costs put up to try 18 cases throughout the country in state and federal court. In the NFL litigation, for example, there wasn't one trial, and we were able to get to a result. So I'm constantly approaching my counterpart on the defense side early in the case, and I do it in every single case, and I say, do you think we really need to have trials? Because I'm going to be honest with you, and we're trying cases against each other. One area I did agree with you, Tim, on is I'm not sure how valuable these trial verdicts are. They're crazy. They're all over the place. I have a lot of respect for the jury system. Huh? There are a couple things you said.
Crazy?
He also agrees there are a lot of
the verdicts are all over
claims.
the place, but every time I talk to my friends on the defense bar, trial lawyers like David, excellent trial lawyers, and we could sit and have a glass of wine over this, and we probably would end the discussion the way we started. What's the alternative? The trials do provide some information about the case. It says something about the case if a jury says, yes to plaintiffs and no to defendants, or yes to punies or no to punies, as much as I know that's a controversial topic. It says something. I don't know what it says. It may not say what the number says, but it says something about it. So I am a big proponent. Here's another thing we agree on, Tim.
All right.
Summary jury trials. I'm a big fan of them. But those have been rejected by defense lawyers when I've proposed them. I said, he hates it.
No, I think that there's zero empirical evidence they're predictive.
Well, there's not empirical evidence for a lot of stuff, but you know what? We used to think trials generated a lot of data that was informative to help settlement discussions. And now I'm hearing both sides say, I'm not so sure they are. So maybe the idea is to have the judge preside over, 2 or 3 different panels and let the parties come in and put their case out there and get that data. What's the data you want? If the injury occurred before the label change, maybe that has more value than a post-label change. If the person's a smoker versus, or he has obesity and it's a heart attack case, how do they see that? You can tease those issues out probably, and I did this once in a case, and it wasn't an injury case, personal injury case. It was an economic loss case, and I think that all sides got to a result that they were relatively happy with based on that information. So, so we agreed on 2 things so far. But so anyway, that's my response to that.
I think you left out that you agree there are a lot of frivolous claims filed. That would be number 3, right?
So, meritless.
But let me say this too, and I'm not just saying it because we have a judge here. I've said this at conference after conference. You know, this idea that, you know, judges aren't following the rules or judges are, you know, we have to look at, you got to look at the whole picture. You can't look at one case. I could sit here and give you, I mean, the Zoloff litigation, which is in the EDPA, you know, was dismissed on Daubert in summary judgment motions. The case went away. That happens. I don't hear that really. And look, you know, I understand I'm probably the only plaintiff's lawyer here today, so I don't want to be beat up.
Selvin will be here.
Oh, Selvin will be here? So, well, if I get beat up after the conference, he won't be much help. He can't fight. So, but,
I'll
you know,
help you.
we could all sit and complain about that judge or that case that went sideways or south on us. But at the end of the day, I do think the process works. I think that I like MDLs for a different reason than fees, because my firm is going to be fine. I don't care where you put these cases. We try cases, we litigate cases very hard, and we have very good lawyers. We are going to be okay no matter what rules get passed, unless, you know, it all goes away. So it's not about that. It's about, but for us, it's about, you know, we think that we tend to bring very good cases. We think others don't, and we think that when you look at, if somebody were to do the analysis, a professor like you or somebody else, Brian, I think if you look at MDLs as a whole, I think the rulings are all over the place. The bad cases get dismissed. Cases that survive summary judgment and Daubert go to trial or get remanded, and they're going to settle at some point because you can't try 5,000 cases. That's a fact. You just can't. So.
Thanks, Chris. You know, Andy, I know you're very involved in proposed amendments to the rules. Following up on something Chris said, isn't a remedy just to follow the basic rules that are there already? You know, get the medical records authorization, collect the medical records, and then I think David alluded to this, but going back to Dan's example from Zofran, look through the billing records, figure out who actually took the product, and then just go to the plaintiff's counsel and ask them to drop cases where that evidence isn't there. Is that the remedy, or do we really need, you know, something more drastic in terms of rules or statutory changes?
You know, it'd be great if that were the remedy, and I think in individual cases it can be the remedy and has been the remedy. And in fact, what I was thinking about as everybody was talking is that there are basically 4 different approaches that at least defendants have right now to dealing with the MDLs and the problem of what we can call frivolous claims, meritless claims, claims that zero out before settlement. I think is actually a great criteria for what we're talking about. It's the ones that aren't going to get money at the settlement but somehow exist in the docket, because those are the ones that both sides are concerned about. And I think that there are a couple of different approaches that defendants can take. And the question in each case is just, how much effort is this? How much will a judge believe that this is a proper remedy? How much can you convince the other side? And to take them from sort of the, let's call it the one that needs the least amount of other people involved to the most amount of other people involved. The first one is that the defendants can just stand on their rights. I mean, as a defendant faced with an MDL, whether it's a medical device or a pharmaceutical one where you have huge numbers of claims, right down to like a number of the ones that I deal with tend to be MDLs that are just consolidating class actions. But, you know, we're consolidating, say, 40 or 50 different single state classes into a single litigation. And one of the things that a defendant can do is to simply not agree to a lot of the shortcuts that make it nervous. And there's some degree to which you can get traction doing that by saying, for example, you know, we are going to move to dismiss these claims, and we're going to move to dismiss, you know, we know a proper list of the plaintiffs and we know who's pled and who hasn't. The difficulty there is that sometimes either the plaintiffs or the courts or the plaintiffs and the courts together have implemented certain shortcuts that from their perspective are completely legitimate administratively, but do preclude things that are ordinarily done under the rules in an individual case. So one of the big issues that does come up is, for example, everything gets consolidated in front of an MDL court, you file a consolidated complaint, and the question becomes, is that consolidated complaint a pleading, or is it just a summary of everything that's going on? Because if it's just a summary, then the fact that it's not actually articulating any individual facts about any individual plaintiffs isn't as much of a problem for the court as if it's actually a pleading. And that's a very real debate that goes on as to whether or not these things that look like pleadings actually are pleadings, and whether the defendant is allowed at that point to move to dismiss individual claims where the complaint itself hasn't gotten to the point where a fact sheet would help. Where you're not even alleging that there was a doctor involved or that there was a harm involved. And there are a lot of MDL complaints that take that kind of shortcut. And I think that's one place where one could stand on one's ground and say, no, we're not going to allow for these shortcuts. The difficulty there is, of course, if the court is already convinced that there's a problem, it may not want to have that fight at the pleading stage. It may want to put that fight off a little bit. And so it may rule, and there is precedent out there at the moment, that, well, administrative complaints are something that we have now, and so that's not something you're going to be allowed to stand on now. That, understandably, I think makes a lot of defense counsel and clients fairly nauseated, because we're used to dealing with individual complaints with actual specific facts. And class action complaints were difficult enough where suddenly we were abstracting issues from their facts so that they could survive longer into the litigation. And when that begins to happen where there's not an aggregated mechanism like this, it can be fairly frustrating. So that's the first one, and it really becomes a court and forum dependent tactic. In some cases it works, in some cases it doesn't. It's the kind of thing that you would hope would either consistently work or consistently not work. But it's something that the defendant can do on their own. The second thing you can do is what the academics in the room would probably call private ordering, which is if you're lucky enough to get Chris Seeger on the other side, you go to Chris and you say, look, that we've got to prove some of these things out eventually in one direction or the other. Why don't we figure out what the proof is that you're going to need to include, either plead it in the complaint or provide us with the following 5 documents. I do not blame Chris in the slightest for getting out ahead of that and trying to go for the minimal end of the proof. If I were on the plaintiff's side, that's what I'd do. That to me is good faith litigation. You figure out what the issue is and you try and tilt it a little bit to your side. But there is something where if you're lucky and you get a steering committee that's thought through these issues and has thought through where the ball's going to, or where the puck's going to be in 2 years about how frustrated courts are about it, they are going to get ahead, and you might be able to negotiate that out. The difficulty is not everybody in the MDL world is Chris Seeger. And I say that having now been on a number of panels with Chris. He is one of the more reasonable, forward-thinking, willing to actually stake out ground of agreement, which is not always something that happens on these panels. And so I would consider myself lucky having Chris on the other side, whereas there are other counsel where I might consider that to be, I might try it, but I wouldn't be holding my breath for a good result.
If I hug you publicly, would that be a little
That wouldn't be good for either one of you.
It'll make me feel nice, but
You'll never get hired again.
yeah. The third thing, and I think the next two are, I think, where defendants and, where at least LCJ and a few other organizations have been going over the last few years, are to aim towards areas where you don't necessarily have to rely on the good graces of the court or the plaintiff that you're with, but you are going to have to get somebody else involved. And so one of those is to go to the rules committees and to say, look, there's an issue here, and it's a civil rules issue because it's smack dab in the middle of what the rules are supposed to govern. The rules of civil procedure take you from the complaint through to the end of the appeal, and there's supposed to be something there to provide guidance at every stage. And some of these questions could be answered fairly simply. So LCJ, I know, has just put out a public comment, and I'll describe very briefly what some of the content of that is. But it's made a proposal that I think is actually really elegant and not one that I had considered on my own until other members of LCJ had brought it up, which is everybody always talks about, okay, well, why don't we amend Rule 8 or amend Rule 9b to add an MDL provision so that it would be like fraud in MDL or under 9b. One possibility is just to amend Rule 7. And for everybody in the room who is not immediately familiar with Rule 7, which would be, I would hope, almost everyone, because it almost never comes up. Rule 7 is the one that actually defines what a pleading is. And so it literally just defines, this is what a complaint is. And put something in there about what it means to have an aggregated complaint. When you have consolidation of, a number of things under, the MDL statute, section 1407, that is a pleading under Rule 7. The moment it's a pleading under Rule 7, it's subject to Rule 8. It's subject to Rule 9b. If you're, alleging things, they will have to be plausible under the Twombly and Iqbal standard, which takes out, actually, I think, the need to call for a lot of fact sheets. Because if you're alleging that you were harmed but you don't allege the exposure, then you can just be dismissed. And that's the kind of thing that I think also would mean that you wouldn't have to do a huge amount of evidentiary production. You might still have to do the evidentiary investigation ahead of time to comply with Rule 11, But, we'll see whether or not that works. Now, the question is whether or not the advisory committee thinks this is a good idea, whether or not that survives the 2 to 3 years of advisory committee debate. Anybody who watched either Rule 26 or Rule 23 get amended knows that those are very big ifs, and very big whethers as to what they'll look like at the end of the day. But it's at least one way that one could go to try and say, look, there are some fairly simple ways to sort of remind everybody what's already in the rules and to say the rules do apply when you get to MDLs. The final possibility, and it's another thing that a number of organizations and interest groups have tried in the last 2 to 3 years, is to go to Congress about this, because when you have Congress on the side of your side of the litigation reform debate, it's certainly helpful to try and get them to move. We will leave aside for the moment whether or not the current Congress is capable of accomplishing anything, because I think that is a very fair question and a robust debate on its own. But one of the reasons why we have a current version of FCALA, or the Fairness in Class Action Litigation Act, is because there were people who thought so long as we've got people in who do not tend to accept money from trial lawyers and the trial lawyer lobbies, it may be a good time to try and get some movement forward on both class actions and mass tort litigation. Don't ask me why mass torts didn't make it into the title of the bill. It's not for the acronym, because FCALA doesn't mean anything as far as I know, but I guess FCALAMA would sound even more awkward. But there are a number of mass tort provisions in there, 1 or 2 of which would have to do with providing fact sheets. Once again, something that we would hope to do through private ordering, but you can't force people to do it right now, and I guess the idea would be now we could force them. The other things that go in there are some other ideas that I think match up with some of the things David was talking about other issues that don't look at first like they have to do with the meritless claims or the zeroing out claims in MDLs, but would have a very real effect. So, for example, if you have disclosure of people who are funding the litigation, that actually gets at this sort of second or third tier of claims that Chris was describing, where you have some lawyers who go out, often they do it in conjunction with a hedge fund or with a litigation funder, and they just run ads, and they just grab people who may or may not have a claim, and they toss them in the docket, either original filing or filing and then getting themselves transferred. They're going to zero out at the end, but they're hoping you'll pay them to go away before that happens. And if you have to disclose the source of your funding ahead of time, that gives you a big red flag as to whether or not you are one of the people who might be filing claims that are more or less meritless. When we mentioned this provision in front of a number of judges at the Emory Institute about 6 months ago, and I think Chris was there at the time, the judges were fascinated by the idea that there was this third-party litigation funding going on. It really had not crossed a lot of their radars, and I've actually seen since a couple of rogue opinions in the wild where judges on their own have sua sponte begun to ask for this information. So that's one that I think actually could get some traction. But the idea is, for example, that's a disclosure requirement. It's not actually completely foreign to what's already in Rule 26, where defendants have to disclose the insurance that may or may not be paying for the claims. And it would have an actual effect on the number of claims that might zero out at the end, because the junk inventory does tend to come from areas that are not necessarily the people on the steering committee. If you think about it for a moment, this is me being completely cynical about the way plaintiffs are set up, and I'm pleading cynical first on this. You've got the people who make their money by actually filing claims with merit, and that allows them to leverage themselves up into the steering committee where you have control over who gets paid, and therefore you can kind of get your own firm some more of the payment. That's the really cynical end of it. But also, real claims are probably going to pay.
That is cynical.
Yeah. At the other end of the spectrum are the people who have no hope of making the steering committee but are hoping to make it up in volume. And those are the folks that we're actually concerned about if we're concerned about meritless claims. And those are the folks that you can actually either expose or begin to get rid of if you have provisions like that in place. So I think on the one hand, yes, standing on your rights can be a remedy for this in certain circumstances, but in other circumstances, you're running up against a number of pieces of institutional momentum and sort of the trends of the last 20 years where it's a little bit more difficult to just stop and say, can't we just use common sense here? Because there's a common sense that's built up around MDL litigation over the last 20 years. And for that, we may actually need a legislative or a rules proposal.
Great, thanks. Judge Robreno, Chris had mentioned that there have been these examples like Zoloft, but you could add many others, incretin mimetics or the Mirena breast implants, Meridia with David, Meridia, old one but good one, where the courts have granted these omnibus motions, getting rid of the entire litigation in MDL proceedings. And it seems like a lot of the real concern now is with the case-specific issues. did this person take the drug? Did they really have the particular injury that's alleged? Was it caused by the drug in their case? And it seems like your experience in the asbestos MDL might be particularly relevant because there you're not debating whether asbestos can cause mesothelioma. That was litigated in the 1970s. You're really doing the hard work of going case by case and resolving thousands of cases. And maybe you can share with us your experience and how it's relevant to this debate.
Well, thank you. Just a couple of comments about what my colleagues have said now and the call for changes in the rules and amendments to the MDL process. And it brings to mind Churchill's famous quip. He said, "We got enough problems, and on top of it, they want reform." I think there are two laws of sort of rulemaking that we need to keep in mind. First, do no harm. We've had the experience recently with the summary judgment amendments, which I think was quite an embarrassment to the Rules Committee. After going through an extensive process, 2 or 3 years later, they had to change the rule because it didn't work. I think, secondly, is a law of unintended consequences. We don't know how something is going to work until it's put into effect. So I would raise the bar a bit to those who want reform. Not only do they want to solve a problem, they should have a compelling case why we must change the rule. Simply marginal improvements in the rule, I think, are too risky to undertake. And that's just sort of a global view. I think there can be some changes. The Duke University folks, I think, have put out a best practices for MDLs and complex litigation, and others in very thoughtful manner have advanced solutions to some of what is perceived to be a problem. The second problem with the rulemaking process is that it freezes in time the innovative process. And one of the advantages of the MDL is that it is perhaps among all types of federal cases, the ones in which innovation of thinking and of procedures is more common than in every other case. A rule would freeze that type of innovation. It would pick out those parts of the innovation that the proponent wishes to incorporate, but it pretty much would then lay out the path, and judges would be curtailed in their ability to innovate. The other aspect is that there are many types of MDLs, and I think that the discussion so far has dealt with large pharmaceutical MDLs, which seem to be the ones that are in vogue now. But there are antitrust cases that there may be 4 or 5 plaintiffs in those cases. Securities cases, consumer cases are becoming increasingly more common. Wage and hour cases. So each of these cases really requires somewhat of a unique approach, depending upon all of the circumstances involved. And while I think it's worthwhile looking at whether or not some particular rules are necessary now, I would caution against 2 things. One is asking for Congress's help, and 2, expecting too much of the rulemaking process, which, by the way, I participated in rulemaking process, is an extremely thoughtful, is really a part of the jewel of the American judicial system. And when you go abroad and you talk to judges or practitioners in other countries, they really marvel as to our system of rulemaking, and it's certainly not perfect. No human institution is perfect, but it's one that it has served us well. Now, there's been 2 or 3 shifts in a global sense in litigation. One, in the rulemaking process, when the rules were instituted in the 1930s, the idea was, let's get everybody into court. All you needed was to say, you owe me money, and you got to pay me by this day because I sold you 10 widgets, and that was it. The more the merrier. And it moved the old pleading rules from the pleading aspect to the discovery aspect. And he said, okay, well, I don't know how many widgets, don't worry about it. You'll be able to take discovery, and you'll find out the answer to all of these questions. Over the years, we have sort of reverted back. The Supreme Court, of course, has helped that process along and said, no, you've got to do it out front. You've got to be able to get a ticket of admission to come into federal court. You can't just pay your fee and get yourself a judge, and you're in business. I think Professor McGovern was here earlier. I don't know whether he's still here, but he has a phrase that he calls it, if you build it, they will come. That is, no matter how you streamline the process out front, unless there is a toll gate that is going to screen out the cases that come into the federal court under the current interpretation of the rules, it will clog the arteries of that particular case to no benefit to either the plaintiffs or the defendants. Two other points in a global sense. I used to be a trial judge. I am now a pretrial judge. Trials have disappeared pretty much. Over 98%, maybe even 99% of all cases that come into federal court do not get to trial. They're either dismissed or they're settled. And those who get to trial are unlikely to be cases involving aggregate litigation in a general sense. So we got to adjust to the reality that all the action is going to take place in the pretrial area. And I always marvel at law school curriculum, which talks about moot court and trial practice, but doesn't teach the students how to take a deposition. I think that's where we are. You get up in the morning, and what are you going to do that day? You're not going to go to court and give a closing statement. You're going to take a deposition, file a motion to dismiss, talk to the judge about scheduling the case. The day-to-day, perhaps less glamorous function of being both a lawyer and being a judge is what we do on a day-to-day basis. So we have to understand that. And the second aspect, and I think I heard the figure 25% of MDL. My understanding, I believe, is 35% of cases in the federal system today are in some type of an MDL. And that's in excess, obviously, of 1/3 of all of the cases. And that's, again, an area of growth and where the action is. So if we managed the pretrial process and if we set the MDL process or the aggregate litigation process in the context of our current rules, I think that the future is not as dismal as it may otherwise appear. As far as the asbestos case is concerned, since my article got it plugged, I brought it along. That is the Federal Asbestos Products Liability Multidistrict Litigation, 23 Widener, Law Journal, 97. I always say I was selected for this task of handling the asbestos because everyone was sure I knew nothing about asbestos or the MDL. So I was a perfect candidate to try to deal with a litigation which had, I took over in 2006, and we just celebrated 26 years, the longest running, largest MDL in the history of 1407. But it was innovative, and not innovative because one person, one judge, developed a particular system, but it was innovative in a sense that it brought all of the parties together and created the dynamics in which the cases could be resolved. Either they will be tried, they will be settled, but they had to be moved. And that required the participation in their self-interest of the plaintiffs, the defendants, and the court. And I think each case has the potential for innovative solutions in the self-interest of the parties, and that the MDL process is really one that foments and promotes that kind of cooperation. So I think the future is bright.
David, going back to you, do you have any thoughts about this debate between Judge Robreno and Andy about whether we need rules changes, or what do you think? Can we do it using the current system? And
No, we have to, I think, of course, agree with Judge Robreno on all fundamental points, most of which escaped me. So I'm now going to go down the straight and narrow path. No, I think that this is a situation where MDLs and mass tort as an issue has been out there for almost the entirety of my career. Indeed, I probably owe a lot of my career to the issues of mass tort. And for the most part, they really haven't changed. What's changed is custom and practice has changed in the federal courts. It's become more narrowed towards a kind of conventional wisdom about how to handle these cases. And I think that is fundamentally a big source of the problem, is that it hasn't evolved in a way that solved the underlying problems. So I think that we have had...
But what is the problem?
The problem is that the cases have become focused on something that fundamentally lies outside the statutory mandate. Statutory mandate is for pretrial proceedings. Mm-hmm. And I completely agree that that's where the work really has to be done. But that leaves the judges in a position where they feel like if they make a decision that's a big decision, immediately it's going to go up on appeal, and they're interested in resolving the litigation. Yeah. And so the way to get to a settlement and to get the cases off the docket is not necessarily to grant pretrial motions. I'm not suggesting that they're skewing the decisions in that direction, but there is enormous pressure on those decisions, and I can see the judges saying, "Oh, wait a minute, I want to try a couple cases."
But David, the problem isn't really a rule-bound problem. The problem is a cultural problem, and I addressed some of it in my article, not by way of original thinking, but by collecting what the thought is. The judges who are assigned MDLs, particularly high-profile MDLs, historically have viewed their role as resolving the case, not as being simply a stopping station in the way to returning the case to the transferor court. So once the case is transferred, and I think, again, Professor McGovern has the statistics, I think it's over 90% of the cases never go back to the transferor court.
You have to say A, Y, and B.
Well, I know why.
And B. Isn't the cultural problem the only resolution to the cultural problem is rules? And so whatever it is, if it's cultural, if whatever it is, we've been dealing with this unsuccessfully for almost 3 decades. And the issues are identical to the issues when I began. And so we're now at a moment in time where there's a broad sense that the system isn't working. That's just a fact of life. Is legislation going to solve the problem? I think that that's a very kind of almost ham-handed environment for dealing with a very delicate problem. So you're left with the rules, and yes, there are unintended consequences, but who is in a better position to solve a procedural problem than the Rules Committee?
Well, the Rules Committee right now, I mean, if you follow the rules, the cases come in for a pretrial process, and then they are remanded at the conclusion of the pretrial process. I remanded 3,000 cases to the Northern District of Ohio, provided that the judge views that end as part of his or her duties in the case. And I think that's an important consideration, and I think it's beginning to shift. I think you see an increased number of cases that are remanded. I'm not sure, David, that the lawyers are all that happy having the cases go back to the transferor court.
That was the conventional
Yeah.
wisdom.
Yeah.
I had this debate with Herb Wachtell in the tobacco litigation. Well, do we really want the MDL? Do we really? Everybody keeps on debating these things, but you can't escape the fact that there has to be a rule-based solution because this is a procedural problem. And let me add to that, how I hear it said in this room, well, the mandate is for pretrial proceedings. Mr. Pratt says that. If you make that argument to a judge today, and I won't pick out any particular judge, they'll say exactly, Judge, what you've said, which is why doesn't the transferee judge have the obligation to seize upon the opportunity to push for resolution? There's nothing that says that they can't do that, and particularly when most of the cases are direct filed in the venue, well, the transferee venue isn't that right. And the answer is, it may be that as a matter of judicial management, it's a sound idea to resolve the case if you can. But you can't do that. The whole basis for what constitutes a fair settlement is the fact that there is an opportunity for fair litigation that's thoroughly explored. There's no other metric for fairness than that the alternative is available to litigate on an effective basis. And what we're struggling with is how do you get effective litigation pre-trial? How do you get that? And particularly when you're dealing with mass litigation. And that issue has been addressed in asbestos. Judge, who was the judge down in the Fifth Circuit? Tremendous. He had the cases down where there's a whole series of asbestos cases in the 90s where they were trying to deal with the problems that we have today in asbestos. How do you litigate 5,000 cases that are down in federal court in Texas? They used class, that didn't work. They used trying to do litigation-based, issue-based litigation. That didn't work. So we're now wrestling with the same problem. How do you get pretrial proceedings? And I believe that there are many things that can be done pre-trial that result in highly effective pretrial litigation of what Duke would say are cross-cutting issues. And I think what we should be focused on is, okay, you get pretrial litigation. How do you litigate pretrial effectively, not just the preemption issues and not just Daubert, but what these cases are about, so that you're getting traction with issues where even the plaintiffs will say there was real issues. And I think, in fact, the litigation that Chris and I have over testosterone in Chicago, I think Judge Kennelly has had a very sophisticated approach for understanding the pool, using the plaintiff fact sheets to gather data about the pool, stratifying the pool, identifying cross-cutting issues, and then having discovery of bellwether cases, which are there in any event, to provide the factual record for resolving those issues. Now, I differ somewhat with how he's resolved some of those issues at the end of the day, but I think that the structure that was applied in that case has been highly effective. And that's where we need to focus, is how to get bellwethers selected in a representative and productive way, how to get the litigation structured around cross-cutting issues, how to stratify the pool so that we know what our pool is in those cases. And we didn't have to spend $10 million gathering medical records to do it because the PFSs were pretty darn effective. So I think that that's where the focus is, and if we don't seize this opportunity, boy, I think that we're in for another 10 years of the same problem.
I haven't seen the problem. I'm just missing on somebody identifying. Maybe you could take a crack at this. What exactly is the problem? I'm lost. I mean, we need rules to fix what? The fact that you don't want to try cases in an MDL court? Well, then just tell the judge you don't want to try cases. Nobody.
I'm not saying you don't
No,
try
not
cases.
you. I'm not focused. I'm focusing generically. I'm saying, I don't mean you. I apologize for that. No, I'm just saying, but if the complaint is you don't want to try cases in the MDL court, then go ahead and say, look, we think we've gone as far as we can. Judge, please remand. Here's my experience, though, which is different from yours. And different from Molyneux's, frankly. In every single case, and there have been many now, over 25 years, every single major MDL I've been involved with where the judge has said, you've tried some cases, I think I've gone as far as I can go, you know as much as you need to know, and if this isn't enough to settle, we're going to begin remands. Every single time the defendant has said, no, judge, hold on. Don't do that just yet. So look, before we go changing rules that will create a new set of rules and interpretations and new problems, why don't we all just say, fine, let's not try cases in MDL. Let's all agree to remand. I mean, in the cases I'm in with anybody here, if you want to remand cases back, let's do it. I'll agree. They can go. They can go to every district in the country.
In fairness, I don't think that is. I agree with you.
Tell me what the issue is.
I agree with you that there's a real downside,
Yeah.
and I think largely it was because in some of the major mass torts in the early 2000s and the 1990s, the volume of cases was so enormous, and the ability to stay in federal court was so minimal that the real threat was vast state court litigation.
That's
and
true.
I think that's fundamentally changed. I think that most of this has really become federalized.
Mm-hmm.
And because it's become federalized, there's now more control in the MDL. So you have remands, they get remanded back down to other judges. But I think that the issue of remand, again, we keep on getting distracted. The issue is not whether cases ultimately should be tried. I don't even think the issue is whether there should be bellwethers. The question is, what are the cases that are selected for initial trial? The real issue is, how do you structure the pretrial process so that you're getting information on the basis of which to understand who is in the pool, and then a procedural vehicle that gives you litigation of individual cases and big picture issues with the same quality of scrutiny and the same burdens as if you had one individual case. There's no reason. This is not class action. If you have aggregated litigation while there's enormous pressure to get efficiencies, the rules only permit you to do that under Rule 42 with a consolidated case involving an issue or class action.
That's a little.
But they do not permit you to alleviate the burdens and sacrifice the quality of litigation just because you have 5,000 cases versus 100.
But they
So
alleviate those burdens for your side tremendously. And Tim, putting aside your 25 depositions of one witness, for the most part, it's one deposition of a witness. And you are right. The fact that state court litigation has now been elevated into the MDL for the
Now,
most part.
let me just make a point
Go
here.
ahead.
The fantasy that lawyers actually want to try cases is long gone. We had 180,000 cases, we had 3 trials. I said, anybody who wants to try a case, 30 days, we'll have a trial. So whether it's in the transfer court or the transfer court, there are going to be no trials. Once in a while, one may slip through, and is viewed as a failure of the system. Now, we have departed from a justice model to a business model. And a lot of the discussion is how do we, in a business sense, resolve these issues? Plaintiffs will get some money, the lawyers will get paid, the judge gets rid of the case, and it's a successful business transaction. Now, there are real people who brought the suit, and they're real defendants who have to write a check. That's ultimately, perhaps we should refocus. What we did in the asbestos case was to have one plaintiff, one claim. In Mississippi, we had a case. I think there were 2,000 plaintiffs in one case. We said, okay, now there are 2,000 cases. Go and do discovery, and set the matter. Treat them individually. The lawyers themselves will work the dynamics, but with the cases will get resolved. You would be crazy not to settle a case that is going to cost so much money to litigate. They will know better than the judge. I view the role of the court and the role of the judge as being able to bring together the parties, put them on a path to either litigate or settle, which are really parallel tracks, and let them do their business. Let the lawyers be the lawyers. The judge has to make rulings. Maybe you were raising the question that some judges avoid trying to make critical rulings. And if there is one aspect of MDL that I think is subject to some valid criticism, is the fact that once a case has been consolidated and transferred, there is no mechanism by which that decision can be revisited as far as the judge is concerned. And things happen. People get sick. For whatever reason, the cases don't move. and there is no real mechanism. I don't think you want to go before the judge and say, Judge, I think it's time for you to retire and move this on to somebody else. There ought to be some mechanism by which you can, and I had suggested over the years that and I must say no one has ever agreed with this suggestion, so I'm in good shape, that there be the designation be for a 5-year period with a presumption that the judge would be reappointed to that particular position. Now, that's very novel in the federal system, but perhaps it can begin a discussion. The panel is very reluctant to get involved in substantive decisions because it doesn't view its role under 1407 as impacting the actual movement of the case. So it would be a difficult task. But sometimes just raising the issue and putting it before before the panel may be something worth discussing.
Just, I believe, Judge, with complete respect, that the idea that litigation is a business proposition is fundamentally wrong, and the rules it may be that people treat litigation privately that way, but that's not what the courts are for. They shouldn't facilitate it. If they are in fact facilitating it, that's a problem.
Well, I wasn't promoting it. I was describing it.
But that very
describing it to people like lawyers who have made it a business proposition.
Right, but then if that's true, then there ought to be a reform.
Maybe we'll have a rule that it should be a matter of principle, not a matter of
No, we should have a rule that the rule of law applies.
Sure.
What happened with asbestos also is sui generis and had the effect of bankrupting over 35 different companies, because what happened was that the system accommodated claims that are no longer permitted. The kinds of claims that came into your court
Because
were
defendants
claims
were paying those claims.
Well, that's right. They were paying those
So
claims.
you created your own problem.
Well, then I guess that's the chicken and egg problem. But all we can do at this point, again, is to focus on the rules. And why we wouldn't do that, I still don't understand why we wouldn't fix a problem when we can see it. I just don't understand that proposition.
Because we don't all agree on what that the problem is there, and then we're probably never going to agree on the fix.
Yeah, I think we have a question, somebody waiting in the audience.
Yeah, so in trying to assess what we should require of plaintiffs at the beginning, whether they need to submit some documents, whether they need a doctor's note, how much we're going to ask of them, I'm trying to figure out what exactly is the downside to having all these meritless claims just sitting there. If we can structure settlements that zero out these claims at the back end, what is the problem with just letting them sit there until then? Is it a problem because the judge sees 10,000 claims as opposed to 5,000 claims and therefore thinks, oh my gosh, there must be something to this case? Is the problem that the shareholders of the companies have to be told, oh, we got 10,000 cases and that looks really bad, and so the stock price drops? What is the problem of just letting them sit there and getting zeroed out at settlement?
Well, you've identified two of them right off the bat, I think, which is they do sit on the books. That does have an effect on the share price, and it does have an effect on the company's decision-making, and it's a drag on the company's decision-making, as well as just being a drag. But, I mean, it's one of those things that actually is a very real concern. And then the second one that you identified there actually has been some, I think it's a Dutch professor who's actually published a working paper called The Law of Large Numbers. And he goes into the fact that the larger you make claims, the more likely it is that judges will treat them as individual juridical entities to be dealt with rather than aggregations of individual claims. So if you say one person's got a problem, it's treated like an individual case. If you say 10 people have got a problem, it's treated mostly like an individual case. If you say 100,000 people have a problem, even if it's the exact same set of individualized issues, suddenly you have a crisis, and we can't actually look at the facts of every one of them. We have to do a bunch of shortcuts. And there's been some psychological research to back that up. So that actually is a concern as well. The third thing is, so long as they're sitting there, they've got to be dealt with. And that means motions practice. That means discovery, because any lawyer who ignores a sitting claim because they figure it'll get zeroed out in litigation is going to be subject to a malpractice claim themselves. And that's one of those points at which legal ethics and the structure of an MDL kind of intersect in an unusual way, because we do have to pay attention to those. We literally would be derelict in our duties not to, and that's additional time, cost, and transaction cost.
But none of those problems I understand the concerns, and I think they're real, but none of those problems are resolved by some of the things we've talked about, because if there's 10,000 cases and we go ahead with a full-blown Lone Pine report, Rule 26 reports and the whole bit, and that eliminates 3,000, you still have 7,000 cases, and I think you still have a problem. Look, once, believe it or not, in all these litigations I've had, I actually have become friends with people who are like general counsel level, not you, Tim. I would like to think of you as a friend, but this is not being attributed to you. But I've had discussions over friendly dinners when cases were over, and it has been described to me very consistently like this. If I have 100 cases against me, that's an acute problem. I can deal with that. If I have 100,000, that's a chronic problem. There's a whole different analysis that goes into solving that problem. I just don't know if the problem is any less if we take the 100,000 down to 20,000. So I'm not sure this is why I keep saying, I like to think of myself as somebody who's a bit of a problem solver. And when I settle cases, the first thing I want to know are your problems. Because if I can help you solve your problems, you can help me solve mine. Mine are generally easier. I need a bucket of money, right? But if we can all have a real discussion about and I'm not saying people aren't trying to address the real problem. I'm just not getting what it is that requires new rules.
Let me give you the calculator.
Can I just finish the thought really quickly? No, just really quick. I get it that some people take somewhat, I don't know if the word offense is right, to the fact that judges say, look, under Rule 16, I can do almost anything I want to do. I can set cases for trial, I can settle cases, I can put pressure on parties. That's what judges are used to doing. Maybe that's the cultural part of the cultural problem that the judge here is speaking about. If you want to eliminate that, well, let's have an honest discussion about it. I don't agree with that, but it sounds to me like what you want to do is take the fun part out of mass torts. And when I talk to law students, I say to them all the time, you should go into this business. It's the greatest thing. We don't have a lot of rules that really apply to what we do. We're always changing them. We're always on the edge of them, and it's a real creative process and really smart lawyers. And I do love working against the people I know in this room. And David, he is really, he hates convention, and it's a real, be honest, from a plaintiff's perspective, it's really exciting litigating against him because he thinks outside the box all the time. So the thing I love about it, I think we were all talking about really eliminating, and that is also bringing the judge into that process. I think that the lawyers have done a good job resolving big problems working together with judges. I mean, we've got massive harms that occur. I understand you guys may not see the world the way I do, but when a drug harms 100 people, it's one thing. But when there are studies out there, let's take the case that we would all agree has merit. There are studies out there, and now 100,000 people have been harmed. We don't have the legal system built to deal with that. So it's judges and lawyers that have to work together to resolve that problem for the company and for the plaintiffs. And
I'm going to make a point here about the Meritless cases. It seems to me there's two distinct types. There is a fraudulent cases, and that's Judge Jack's case in silicosis,
right,
where those weren't really claims. Those were fraud, and the legal system cannot be complicit in maintaining cases in our system which are fraudulent. Then the second type of cases are cases in which, had the person actually been exposed, an injury would have had a case. That is, these are cases in which what's lacking is the actual facts. But they're not fraudulent in a sense. They didn't make up the facts. It's not fake facts or alternative narratives. These are cases in which they just signed up everybody in the union hall. And that's I think where you get into the fact sheet and when you get into some early way of trying to identify those cases. And I think it's important to identify the cases because the cases can move more efficiently, more equitably, and administratively in a much better way if you figure out who has actually been injured in the case, either economically or in a personal injury sense, right out front. And in asbestos, frankly, and I don't know the story before 2006, plaintiffs' lawyers were not at all disturbed that thousands of cases were dismissed because they could not come up with a fact sheet. And they concentrated in the cases in which There was injury, and there was recovery, and then there was a settlement. The other aspect is that they snarl the entire system. If you have so many cases, and you said, I was mentioning it to one of our colleagues earlier, remind me of one of our associates when I was in practice who was given 10 tasks to do, and since he didn't have enough time to do them, he didn't do any of them. And in a way, the court feels that if he has 5,000 cases, how am I going to ever get rid of 5,000 cases? There is some human inertia that I don't think the rules can solve as to how to achieve those cases. So I think it's important for the integrity of the system and also for the efficiency of the system that we develop mechanisms by which you can screen out claims which really don't belong in the courts.
I think we have another comment, question from the
Yes.
audience.
You know, there's been a sort of a repeated refrain of, what is the problem? And 37 years in the practice of law, I can say that, in the first mass tort involving a medical device, the Dalcon Shield, I never picked up a single Dalcon Shield file where the plaintiff didn't, shockingly, have a Dalcon Shield and B, allege that she was injured as a consequence of a Dalcon Shield. Fast forward 30-some years later, and we can be involved in litigation, not just hundreds of individuals who have sued but never took the pharmaceutical, thousands who sued and took the pharmaceutical. And when we were identifying what problem that causes for the company to just park these, well, they're reporting to regulators that they have X number of complaints against a product. It can have the effect of really damaging the product for the long term. And it also, from a regulatory perspective, ends up putting all of these bogus claims in a regulatory context when they have absolutely no meaning whatsoever. And it seems to me that, Iqbal Twombly is supposed to require, from a due process perspective, just a basic minimal amount of information. This isn't Lone Pine. This isn't Lone Pine at all. This is Iqbal Twombly. Who, what, when, where. Identify that you had a prescription, that you received it from, for X product, and that you received X injury. The vast majority of these multi-plaintiff claims, it's I got a product from one of the following defendants, and I might have been injured in one of the following ways. It doesn't meet Iqbal Twombly, and unfortunately, not all MDL judges are willing to address Iqbal Twombly motions at the outset. We'll save that till later. We'll save that till later. And then the defendant is burdened with going through fact sheets, and it's the defendant that actually bears the burden of vetting the plaintiff's cases that should have been vetted at the outset. Judge, I love your idea of one plaintiff per lawsuit. That would get rid of so many cases if just that $400 filing fee, and they had to actually put that in there. Another idea that I'd be interested in your thoughts on is whether a defendant, instead of filing the tag-along, had an option of doing a motion to dismiss Iqbal Twombly in, the transfer court and say, before it goes there, vetted under Iqbal Twombly. And I think that a lot of those cases would never get there because it's not a situation where they can revise it. They never took the product, and they're never going to go. So those are just a couple of my thoughts.
As I understand it, you wonder whether or not, after the case has been consolidated and transferred, whether a defendant could go back to the transfer court? No.
Before.
Oh, before. Well, right. Sure.
You would basically have an option.
Yeah.
You could file the tag along, and if it looked like a good complaint, and you knew it was a plaintiff's firm that vetted their cases, and you had every expectation that if there was a deficiency, it would get fixed later. You could throw it. But if you wanted to, you could file a motion to dismiss and get that heard before it ever went to the MDL. And I think maybe a lot of those cases wouldn't end up in the MDL.
I think that, again, what would happen in practice, as opposed to, it's like I said, it's great in theory, just doesn't work in practice, is that the judge is going to say, this is going to an MDL. Why am I going to allocate time and effort to this piece of it when there is going to be an MDL somewhere, and it's going to stall that proposition. Now, I think there have been, in fact, I think in the NFL case, wasn't there a judge out in Illinois who ruled on it while the MDL case was pending?
Exactly.
That happens, that is
Yes.
not infrequent.
Yeah.
It's that in the stub period of time,
Yeah.
things can be decided. But Mary, what I would
Yeah.
say is, on your point, this one thing that's come out of all these discussions is that there is a difference. Setting aside the fraud claims, there's a difference between people who really can't show they took the drug or don't have an injury versus people who did take the drug, but there's still fundamental problems with the causal relationship. And I think that we need to think about that as having two different kinds of cure so that we're not seeking too little and too much. With respect to the cases where they don't have the product use or it's completely remote in time from any kind of injury, then it may be that pleading is enough, and Twombly and Iqbal are enough. In my experience with Twombly and Iqbal, they don't really solve that kind of problem, though. Twombly and Iqbal are inquiries into whether there's a viable theory of the case, so that you get beyond the formality of the pleading. Does it make sense? Twombly and Iqbal are not particularly good, I think, at ferreting out the cases where there's not support. And so I think that's what I would say there is that you still need something more, and I'm not sure pleadings are going to solve the problem. But I also believe, let's assume you got rid of the 25, 30% of the cases that really should not have been brought. I agree with Chris. You still got a lot of cases that are out there. And I think that we then have to think about the cases that are out there in a way that's suited to those particular problems. And that's where you get to Lone Pine or something that gets to a core issue like, is there a doctor who says that there's a problem? And we can't confuse those because we have to have asks that are tailored to those. And with respect to those cases, the 2,000 cases that are left, again, we really got to think about not just the big picture issues, but the kind of discovery and the kind of litigation that gets you down to, well, is under state law, we have this in testosterone, does the jury instructed that there can be, that it doesn't, the plaintiff doesn't have to show that it's the sole cause, just a cause. That's really big. What if you have a case where there's a predisposition, there are other existing risk factors? Is that a separate cause? That one instruction probably has more to do with the 2,000 cases that are left than almost anything else. And so this is why I think when we think about pretrial proceedings, we have to think, how can we make pretrial proceedings maximally effective to unpack who's in the pool and how you pick out those kinds of issues. And then if you're going to pick cases to litigate, you pick cases that match the issues. And we spent an enormous amount of time. And I think there could be a lot of solutions in that area. And I'm fundamentally skeptical about whether Rule 7 is going to get to that or Twombly is going to get to that. And that's where a lot of the litigation, that's what Chris's people will worry about. They don't worry about the cases that are not so good. They worry about having enough cases that are good that they can get to the jury.
And I think Judge Reeves dismissed almost the entire MDL. Judge Reeves in the propoxyphene MDL dismissed
What?
almost, in the propoxyphene, Darvan MDL dismissed, hundreds and hundreds and hundreds of cases under Iqbal Twombly because the pleadings said, I took XXX or Y product. Well, that's not enough. I mean, if you are one defendant, you don't know which, from that type of a
That's
complaint.
a market share. That's a market share liability theory.
No, it wasn't. Well, that's another issue. But these were factual pleadings
Okay.
that were absolutely deficient, and they were dismissed. And I think that in a lot of MDLs, the judges don't really, they set aside the Iqbal Twombly motions. They'll set aside the motions for summary judgment. I do think a mechanism needs to be thought through that will consistently get rid of all of the bogus cases. So.
So, well, is the issue the bogus cases, or you're only happy, and I don't mean this rudely, but are you only happy when the whole case gets thrown out? Because that's the way this discussion rings to me, because I'm trying to figure out what it is we can do to help. We can help with medical records. We can have those discussions. Pharmacy record, that seems like a minimal thing. Proof of an injury seems like a minimal thing. Turns into a big negotiation. But, I mean, it is. It always turns into more than it should be, is my view, because everybody's trying to get the upper edge. But my point is that problem can be solved. The problem of the fact that maybe there are people here that want to see more cases thrown out completely. I don't know how you solve that, other than winning the case.
I think meritless cases shouldn't be filed.
I agree with
And
that.
then I think that when they are filed, they ought to be dismissed. I don't think the defendant should bear the burden of vetting a plaintiff's inventory of plaintiffs.
Chris, you can
don't
think of this
disagree.
as the non-Chris Seeger, non-medical malpractice MDLs, if you'd like.
Well,
that may help to clarify it for you.
But this is actually a fair point, because there are, and it's not just us, there are other firms that, I think do a really good job on our side. We don't want those claims either. We get stuck with them. In fact, I'm in a case right now. It's a relatively small MDL. Defendant is considering settling. And one of the big issues I'm struggling with right now is I don't want to leave this judge with the crap they don't want to settle. I have an obligation, I got to get my clients paid, but I also have an obligation to the judge. And, going forward, I can tell you in any case I'm in, there will be a pharmacy record and an injury record. Now, we didn't do that in our case, but I think we figured other ways around that. For the
No, we
most
haven't. We haven't really got. We're kind of more
Right.
focused on.
We've done the bellwethers, right?
Well, on the cases
cool.
that are potentially
Yeah.
valuable cases.
But I mean, you'll never get. They're total common ground, and you'd be surprised. I know Elizabeth Cabraser feels this way, and there are a lot of good, plaintiffs lawyers that I think we'd all consider good plaintiffs lawyers that will agree with you on that. I think we just have to push it.
And Chris, do you think that, I think in some of your remarks earlier, do you think that, we talked a lot about the culture here, a culture of settlement, not rigorously scrutinizing the claims. How much of that do you think is due to defendants and their propensity or lack thereof to
A lot of it.
sign a check at the end of the day for
No.
a big number without looking at the claims?
I'm going to tell you, and if we go back now over a 20-year period, and it really did create this problem. I've seen it from a different perspective than you guys have. There was a time, I hate naming the cases because I don't want to implicate the lawyers and the client. I understand they probably had good strategy reasons, but we all know of cases where defense lawyers went around the country settling inventory of cases that included what we call pill takers. Maybe took the pill. Maybe they took the pill. In asbestos, I've been openly critical of the asbestos litigation, and Your Honor, I hope I don't say anything that upsets you, but, my firm could have gotten involved in asbestos litigation, and at some point we did take mesothelioma cases. We got out of it because what I observed happening was non-malignant cases were being settled, and it appeared to me they were being settled on the back of the malignancies. So there's only, we have to assume it's not an unlimited amount of money. So there's a limited amount of money, and some of the money going to cancer victims was going to people with no cancer, or what they called asbestosis. So we just said, I'm going to stay out of it. This looks like a crappy business, and all those guys now are floating around in 200-foot yachts because defendants paid them.
But they paid them is another way of saying we're getting. I know it's the linkage. They were paying. They wanted to lower their total dollar amount, but also be able to say that, relatedly, that their per case value was under control.
I get that. I get that, but I was asked, what's my opinion? Okay, Fen-Phen, I got to tell you, if there were, let's say 100 plaintiffs firms throughout the country, after Fen-Phen, there were 10,000. Because Fen-Phen was an example, and I have a lot of friends on both sides of that, and I hate to be openly critical like this, especially with a camera in my face, but again, company...
That's Chris Seeger.
The company was going around the country writing checks, and I know the size of some of those checks. We weren't in the case. I mean, we're talking about firms that would have been crushed easily by anybody here, making $100 million in fees on things like that. So when you talk about the creation of a problem, both sides have the blame on this one. And I think both sides should work together to solve it. And on your point about litigation funding, I just want to tell you, one thing we are doing in front of Judge Brody in the Eastern District of Pennsylvania in the NFL litigation is I am going after litigation funders and claim servicing companies that have tried to scoop up NFL players, loan them money, send them to their favorite doctors, because they think they'll get a diagnosis. We're all over that. We're bringing all the fraud, all the claim servicers, which are these law firms throughout the country that are advertising for these guys, including the litigation funders, because we're finding there's a connection. There's money going back and forth between them. And I think if we all do that, go after fraud, go after these companies, I think we're going to clean them out eventually. So.
Okay, well, thank you very much. It's been a really great discussion. Thank you.